me and they wanted me to do something like an overview of the conveyancing in the ATP program, and also civil litigation and commercial. So we'll find time for the next sessions to try and do this before your orals, just to get the main areas and the highly tested areas, and then afterwards we'll go deeper into it after you've done your oral exams for the main exams now. Okay, now I'll post the recordings once we are done, maybe tomorrow or the day after tomorrow. So Noah and I will take you through the first set of oral questions before Vince joins. And kindly, who volunteers before I pick? Who's volunteering? Just raise your hand, then you can begin. Vero. Okay, we'll start with Veronica, and then we'll go to Ogola. Vero, then Ogola. Okay, I'll start asking the first set, and then I'll ask the first set, then Noah will take it over. Okay, Vero, how are you today?
I am fine, thank you. Thank you for having us today.
Okay, you're welcome. You're welcome. Now, kindly distinguish between a verifying affidavit, a replying affidavit, a supporting affidavit, and a supplementary affidavit.
Right, if I may just get the affidavits again: verifying, supporting, supplementing, and replying.
Supplementary and replying affidavit, yes.
All right. I would love to first by noting that an affidavit is a sole statement of facts, and the person who swears these statements is called the deponent. So the different forms of affidavits, and it's also worth noting that an affidavit is attached to a pleading whenever someone approaches the court. So a verifying affidavit is generally a sole statement of fact that talks into the issues, or rather the facts that have been raised, to say that these facts that have been raised in the complaint or in whatever pleading that it's being attached to are true to the best of the knowledge of the deponent. A supporting affidavit, on the other hand, most often than not follows the notice of motion, and supporting affidavit deduces some evidentiary purposes from whatever it is following it, and a supporting affidavit generally denotes that this statement was said, and therefore this is what I want to say towards those facts. A replying affidavit, on the other hand, is an affidavit sent by the other party after receiving the supporting affidavit or the initial affidavit. Then the other side replies to the contents of the affidavit using a replying affidavit. A supplementary affidavit, on the other hand, is that after a replying affidavit, there's some issues that have been raised in the supplementary affidavit that had not been adduced in the initial affidavit. A supplementary affidavit therefore goes into giving the facts to support the questions raised or to answer the questions raised in the replying affidavit. Thank you.
Thank you for that. Well answered. Now, what is the difference between give me 3 differences between an appeal and a review? 3 differences.
An appeal comes into questioning a decision that has been made on a case, and it's usually done by a higher court towards the decisions of a subordinate court. And you will find that under the Constitution we have in the hierarchy of courts and the jurisdiction of courts, we actually have courts which are specifically mandated with the appellate jurisdiction. And we also need to note that apart from the fact that it reviews facts, it questions into the facts. In an appeal, you cannot raise new facts of question. A review, on the other hand, is horizontal, in that the court is mandated with rechecking or relooking into the decisions that it had made earlier. So a review does not go into the higher court. We also have to note that in both instances, the court may decide for or against. It is not a one-way route. It's in the court's discretion after reviewing the facts that have been raised. Thank you.
Thank you for that. Thank you for that. Now, what are the principles under Article 10 of the Constitution?
I would love to say I stand guided on the same. I will to misguide the group.
Okay, no problem. Thank you for that. So explain to me the concept of duplicity in a charge sheet. What is duplicity? Or when can you say that a charge is defective for being duplex?
Duplicity of actually, the question of charges is a pretty interesting one, in that you are only allowed to mention one charge in a specific statement of facts. And you realize that we have these articles or these particular sections that mention more than one charge. But again, duplicity of charges talks into you only have to mention one charge. Select a specific charge that you're going to mention in the statement of facts while drafting a charge. So you have to mention a charge that you feel is the more superior. If you feel like you want to raise another charge, then you have to do it as a subsequent charge or an alternative charge, but you can't have two charges under the same statement of facts.
Okay, thank you for that. Now, my that last question before I hand over to Mr. Noah is, what are extradition proceedings in your understanding? What are extradition proceedings, and what is the statutory framework for the same?
Extradition proceedings are these proceedings to I wouldn't want to use the word export, but I would want to use the word giving a fugitive back to their parent state, in that the charges that are instituted against them don't necessarily have to be looked in by a court in our within our boundaries, but they can be taken into the court where the person is a national of that specific court. On extradition, we also have to note that there's so much that needs to go on, in that the court has to be satisfied that whatever charge has come in front of them or before them is a charge that they can't prosecute, or it's a charge that carries so much water that this person has to be extradited. And we also have to note under extradition that to some extent, or it is an issue of question, but to some extent it's with the court's discretion. The court will decide on the weight of what they want to extradite the person for. That is because the court also doesn't want to look like a mediocre body. About the rules that apply to extradition, I will stand guided on the same. I'm a bit confused on the same, given that these discussions that have been arising. So I would like to stand guided on the same.
Also, I was just asking the statutes that govern extradition. Any statutes that you're familiar with that govern extradition?
All right, let me just say I stand guided. Kindly allow me to pass.
No problem, that's fine, that's fine. Are you aware of the case of Republic versus Mwango?
No. I'm sorry, no.
Okay, follow up. Are you aware of identification parades?
Yes, I am.
Now give me in brief just 2 rules that have to be followed when you're conducting an ID parade.
The basic, or what I find the basic rules, is that you have to, the people standing in the ID parade have to have similar physical appearances with a specific witness, with the specific accused, or yeah, with the specific accused. And then another thing is that the accused cannot be forced, and they can choose any place that they wish to stand in the identification parade. The identification parade should have a minimum of 8 persons.
Thank you for that. Thank you for that. That will be my end. And I really appreciate you've answered them very well. You've done particularly well. I will hand over to my colleague Noah to ask you a few questions. Then I will get back to you with my comments and answers or clarification where necessary. So Noah, please go on. Personally, you did very well.
Thank you so much.
Veronica.
Yes, sir.
Good evening.
Good evening to you, sir.
So you can hear me well, huh?
Yes, I can hear you.
So these are my questions. Just relax. Don't be tense. So my first question, though, I'll guide you. Suppose I bought land, let's say 3 years ago. I bought land, some piece of land.
Mm-hmm.
Then the National Land Commission or the registrar, out of the blue, decided to, revoke my title.
Mm-hmm.
So I come to you, Ms. Veronica, as an advocate of the High Court of Kenya, because I'm aggrieved. I don't know where to go. So my first question is, which pleading will you file? That is my first question. Just answer.
All right. So the one thing we have to note is that land matters are generally handled by the lands registry, and if it's a case, by the ELC court. But you also have to note that the registrar has no power at all to revoke title, and the power to revoke title is only and can only be subjected to the court. Only the ELC court can revoke title. So the fact that the registrar goes insofar as revoking the title means the registrar has acted ultra vires. So the process we use to question an administrative body that has acted ultra vires is the judicial review process. The judicial review process is divided into two. We have the leave stage and the substantive stage. And that is, I will first start with the leave stage, and then later I will come to the substantive stage, for which I will use notice of motion.
Okay. Then my second question, though you have answered it, but I'd like to repeat. And everybody listening, I hope you are listening. So the second part of my that particular question is, which court are we approaching? I've heard you answer it. Which court are we approaching? The court we are approaching.
The court you are approaching, let's first note that it has to be a high court. That is the general provision, that whenever you are approaching land matters or when questioning judicial processes, it has to be a high court. And then you also have to note that the high court specifically designated to handle land matters is the Environments and Lands Court. So in this particular case, you'll go to the ELC court.
Okay, fair enough. So I'll leave it at that. So the second part of the second question is an open-ended question. So right now, my senior Salonka and I have asked you certain questions, yeah? And then once you are answered and you are from the panel, while you are walking home, you decided to text the class group of those questions that you have been asked. So my question is it ethical and morally appropriate for you to post the questions you have been asked? Let's assume you are asked the first day. Is it morally and ethically appropriate for you to post those questions that you have been asked in orals to your WhatsApp group to other students that have not yet been examined?
The concept of morality in law is a little bit a complex subject, because what you consider moral, the general public may not necessarily consider moral. But in this specific question, I would like to say that I will look into the purpose of posting this question. Is the purpose for telling people that these are the exact questions that are going to be asked, or is the purpose for telling them that, hey, you can revise on this? These are some of the questions that have been asked. If the third purpose is for scaring the students. So whichever purpose you go with, you come to find that it doesn't necessarily speaks into morality, but rather speaks into conduct. And the conduct of posting the question for either the second or third scenario, for either the first or the second scenario, in that you want the students to use it for revision or telling them that this could happen to you as well, then I don't find any issue with that. In fact, I find it very commendable, because we always say hand in hand we shall get the 9 P's. So it can be used as an avenue for revision. But if you're using it insofar as to scare the students, then it is I will say it is a bit, I wouldn't call it misconduct, but I will call it unconduct. A little bit of an unconduct on your part. Thank you.
My last question is, do you differentiate between a judgment in default, and a summary judgment?
A judgment in default and summary judgment.
The normal judgment, number 1. Number 2, a judgment in default. And number 3, the summary judgment.
All right. A judgment, to start with, once a court process goes, the end game of any court process is to get the judgment, to get what side is the right side. So the judgment is what the court tells you, or rather the final word of the court on the subject matter, the whole of the case, once the case has been completed. A judgment in default, this is a judgment entered in default of the other party entering appearance, such that a notice is given, and if they default, then and they don't come with saying the reasons why they defaulted in entering appearance, or the court is not satisfied with the reasons, then the court enters a judgment in default. But you also have to note that the court has to be very conscious when entering a judgment in default, given that a judgment in default could potentially prejudice the other party. So the court has to be satisfied that if it enters this judgment in default, no one will be prejudiced by the other party's tardiness. Secondly, that if in case anyone is prejudiced, then it can be easily remedied by a simple judgment or a simple issue of cost. And then a summary judgment, on the other hand, is a judgment where both parties have agreed to the concepts of the case or the issues raised in the case, and therefore we don't have to go through the full trial process, but both parties have followed the procedure as it should, but now they don't have to go through the whole court process, because the issues are clear and both parties agree to the issues that have been raised. It's only the question of fact of who is right and who is wrong that is being asked. Thank you.
Yes, thank you very much. That's all from my side. Mr. Solanke.
Vero, okay. Now, for me, my questions, you answered them very well. Give you high marks because you performed generally well for all the things that I asked you. Just a few clarifications here and there. You actually got them, just clarifying. So when you're told to explain on the issues to do with verifying affidavits, distinguishing between the different types of affidavits, it's good. You can give examples of where they're used and even statutory provisions of the same. Yeah. So, for instance, verifying affidavits basically just aver or state that the statements in the plaint or pleadings are true. That's a verifying affidavit. It usually
Go ahead, I'm listening.
No problem. It usually accompanies it accompanies a plaint. It also accompanies a divorce petition. A verifying affidavit is also used in what else? It's also used in bankruptcy proceedings. Now, is it debtors or creditors? It's used in bankruptcy proceedings in debtors, not debtors, creditors application. Yeah. So when you're making the creditor's application, the document that you will use or the affidavit will be a verifying affidavit. But for the debtor's application, it's going to be a supporting affidavit. So, but we'll come to that when we do insolvency, start practicing or revising insolvency with you. Now, supporting affidavit basically adduces evidence of facts, and it usually supports your application. So it's usually used in where it usually accompanies a notice of motion. What else? A replying affidavit. It's used to respond to the facts that have been adduced or brought forth by a supporting affidavit. So whenever you file a notice of motion application, the other person can reply either by can do grounds of opposition, a replying affidavit, or a PO. And the statutory provision for the same is under 51 of the Civil Procedure Rules. Now, the last one was a supplementary affidavit. You actually got it right. So you see, there are some, let's say there's some material or evidence or facts that were not adduced in an earlier affidavit. You can introduce them using a supplementary affidavit. Now, the difference between appeal and review, you got it very right. The principles under Article 10, you stumbled a bit there. And funny thing is, I was asked this question in my orals. I also wasn't 100% sure because the only thing I could remember when it happens to, when you talk about Article 10 was, okay, I knew the topic, it was on principles of governance and the national values. But I couldn't remember it very well, but I knew some few things here and there, and that's what I discussed. So it talks about national unity, patriotism, respecting the rule of law, sustainable development, integrity, transparency, and good governance. So you can just go check out Article 10. I was asked this question. That's how, the lecturer can move from a question that is in the course outline or questions that are geared in the course outline and go to something totally unrelated, like a provision of the Constitution. It's totally possible. So you got it correctly. Now, the other question that I asked was on the issue of duplicity of, was it duplicity? Yeah, duplicity of charges. So duplicity, or when can you say a charge is duplex? That is where you have a charge that has more than one offense in one count. Yeah. A duplex charge is where you have more than one offense in one count. So every count needs to have one offense. Every count, one offense. Every count, one offense. You can't charge someone with murder and attempted murder on the same count. The charge will be bad for duplicity. Okay. What was the other question? There's one particular question I asked, and yeah, extradition. So you explained it very well. You explained it very well. Now, the last, you explained it very well. The only bit you stumbled, the only area you stumbled was with the sections or the law, not the section, but the statutory framework. So the statutory framework for extradition proceedings is, there are two main statutory frameworks. That is Cap 76 and Cap 77. Extradition, there's a Commonwealth Countries Act, and there's extradition, the Contiguous and Foreign Countries Act. So those are the two statutory frameworks. That's all I wanted, those two statutory provisions. Okay, and I think you are good to go. Oh, and the last one was ID parade. So when I asked Republic versus Mwango, Republic versus Mwango is the case law that laid out all these rules on how to conduct an effective and proper identification parade. So the things that you need to adhere to when it comes to ID parades are, maybe if you're writing, the rules are, a person to the case of Republic versus Mwango are, so the parade, let me just check, let me get my some of the materials. So the witness or witnesses, you have to describe this person before even the parade is being conducted. So you're not just called there to pinpoint anyone. Before the parade is conducted, you need to, the witness has to describe this person. You need to take people of the same physical shape, class of life, and so forth. So if it's short people, you need to have all of them being short. You can't have a short person, tall person, short. All of them need to represent the same physical stature, class of life, and so forth. Now, the accused person is free to take any position that he wants or any position that he chooses. I'm trying to simplify it. I had to try, I'm using my material, my notes, and I got them from this case law. And then, okay, this case law and the National Police Service standing orders. After the person has identified, after the witness has identified the accused person or the person who thinks was wrong or who did something particular to him that led to the ID parade, the witness has to go and physically touch that person and identify them. And then afterwards, there has to be a note taken indicating how the witness identified that accused person. And the accused person has various rights. He can change his position whenever or however he wants. And then the number, it has to be at least 8 persons. The ID parade has to have at least 8 persons of the same appearance, physical stature, class of life, the height, and so forth. So those are just but a few. There are so many when it comes to conducting ID parades. There's no need to cram. Just have 5 or 4 with you, or maybe 6, and you'll be good to go. For me, those are the questions that I asked. You answered them very well and perfectly. And if I was giving marks, I would have given you an 18 out of 20. You did well. I can give his remarks, then now we can go to Angola.
Yes, Veronica, you did well, I must admit. And another thing that I must admit, you have no control. The reasons why I asked questions that are a bit different from what Solonka has asked, just wanted to show you that these things happen. Somebody might ask a question like the one that I've asked about you have been asked a question, it has been sent to our WhatsApp group. Is it ethically or morally correct? So you have no control. Questions can come from anywhere. And I must admit, you have done well. I could have given you 18. So my first question, I'll start from the last one I asked, the difference between a judgment in default, and a summary judgment. And I like the way you answered it, and you also gave examples and illustrations. So a judgment basically is the final decision of a court made after both parties have presented their case and have argued it out. Basically, that's the definition. Then when it comes to a judgment in default, normally it's a consequence of non-appearance by one party who has been served. So this normally happens where a defendant has been served and he has failed to file a memo within 14 days. So once they have failed to file a memo within 14 days, then a judgment in default is always entered. It is also final, but it's usually set aside if the other party, normally the defendant, seeks leave of the court by giving sufficient cause as to why he did not make an appearance. So basically, that's an overview of what a judgment in default is. Now, a summary judgment, on the other hand, and I'll refer you to Order 36, usually made when the court, after looking at the facts presented, can decide that this particular plaintiff or the defendant can't prove their case. So normally the judgment is interlocutory. So I'll refer you to Order 36. Go through it, not only Veronica, but the whole class, so that you can be able to understand the difference between the three. Then another thing I asked, and I wanted to guide you, I think my senior Solonka went through this, and I'll just mention it again. That scenario I gave, where the National Land Commission has revoked your title. I liked your approach, how you answered it. You came from a JR point of view. But remember, there is also a constitutional issue being raised in this case scenario. And the main issue is Article 41 of the Constitution being violated by the NLC. So if you feel that the NLC has acted unlawful or arbitrary, you have a right, to go to court and challenge that particular decision. So the most appropriate court you'll have to go is the ELC, a court equal to the status of the High Court, which is the ELC. So what you'll have to do, given that a constitutional right has been infringed, issue of ownership of land, then I'll advise you to go to the ELC by via petition. So the remedies that you'll obviously be seeking, and I'll refer you to Article 23 of the Constitution. You will do one, you'll have to check, you'll have to seek the following remedies. Number one, we'll do a declaration of the rights, including but not limited to a declaration of ownership of land. So we'll seek a declaration that the ownership of or the title to that land has been infringed. Number two, you can also seek an interim order protecting the land from revocation or any other harm pending the determination of that suit. Number three, and when you look at Article 23, these are the remedies that are there. So number three, you can also seek an order of compensation to be issued for the violation of your constitutional rights and actual losses that you have suffered as a result of the revocation of those titles. And lastly, and I remember my senior Solonka said, you can do or you can seek JR orders under Constitution, a constitutional petition. So what you'll do, you'll seek an order of JR, including an order of mandamus, an order compelling the National Land Commission, to maybe perform a particular act, or you can do an order preventing NLC from revoking that title. And you can also seek an order of certiorari, an order basically quashing the decision by the NLC to revoke those titles. So I wanted you to answer that question in that particular way. Though the way you approached it is correct, but the issue of constitutional rights have been infringed. So you'll do a JR in a petition. So that's how I expected you to answer that particular question. And then lastly, the open-ended question that I asked you, whether it is morally appropriate. Somebody's mic is on. Dismas. So whether it is ethically or morally appropriate to post what you have been asked. So a friend of mine, 2019, I was asked this question. So what? This was by Mr. Riri. So I realized that this particular lecturer wanted. This is a question that you have to take your time before you. It might seem easy, but it's a very hard question. So this is more or less a jurisprudence question. So you sit and ask yourself, and I like the way you answered the issue of the greatest number of people being, like impacted positively. So there are very many ways you can approach the question. One, you can ask yourself, is there a law that governs people sending WhatsApp questions to WhatsApp, questions that have been asked in oral to WhatsApp group? You can say it's more morally appropriate given that there is no regulation. Number two, on the other hand, you can also check the concept of the greatest happiness theory. I think it's utilitarianism.
Hello. No, I can't hear you. Is it me or? Can you hear me?
I think we lost no.
Okay. No. Okay, that's fine. That's fine. Yeah, we lost him. I think we've lost him. But it's fine. When he comes back, he'll log in. Okay. No, sorry, we lost you a bit there.
Mr. Solonka, sorry.
Yeah, it's fine. It's fine.
Yes, somebody I think called me. Flashed. So I was saying. The issue, there are very many ways you can answer those particular questions. So you can check whether there is a law regulating. If there is no law, then there is no immoral issue. You can also check the issue of utilitarianism. If that act you are doing will cause a lot of harm or benefit to the larger part of the society. Then number three, lastly, you can also check the impact, the greatest number of people impacted by that decision. So that's how I could have answered that question. Otherwise, Ms. Veronica, you performed well. I'll give you 18.
That's very nice. That's very nice. Okay, thanks a lot, Noah, for that and for your comments. Now, so that we have more guys participating, I can see Kevin is raising his hand and Ogola. So we'll start with Ogola and then go to Kelvin. If you have questions, just note them down. We'll answer all of them. No, unless there's a question from Veronica. Okay, now Ogola, are you ready?
Yes, Mr. Farina.
You can hear me very well, yes?
Yes.
Okay. Now, kindly, what are the principles of sentencing? Kindly give me the principles of sentencing.
Thank you, Mr. Solonka, for that question. I'm just trying to recollect my thoughts on the principles of sentencing, but I can say one of the principles of sentencing is that it should be just, and the accused must be given an opportunity to mitigate his case, and sentencing should be done according to the provisions of the law in place, either the penal code or any other law that puts such penalties. And I think that is how I can approach it.
Thank you for that. Done very well. You're familiar with the requirement that advocates need to have a practicing certificate, yes?
Yes, sure.
kindly in 2 minutes, make what are your comments? Any case laws or any statutory provisions on the same? Just talk about the requirement of a practicing certificate by an advocate.
Okay.
And mention the Locus Classicus case on the same.
Okay, thank you for that question. For you to practice as an advocate in Kenya, you must have gone through the requisite training, and then you must have received your certificate after you are entered in the role of advocate as such. And this accreditation is done by the Law Society. So one of the regulations that guide this practice is the Law Society of Kenya Act. I'm not very versed with the Locus Classica case, but I've read some cases. I can't really point out the citation of such cases, but there's once a case where one advocate was acting for a bank. I think it was the National Bank of Kenya. He was acting without a valid practicing certificate, and when the opposing counsel realized this, they raised that question, and this advocate was indicated for the same. So another regulations is that guide this point is the advocate rules, which also requires that a practicing advocate must have the practicing license for him to carry any such businesses within the jurisdiction of the country.
Thank you for that. Now, have you studied movable property, MPSR, the movable property security rights? Have you studied MPSR?
Yes, of course. We have.
Oh, that's nice. Now, kindly, under the MPSR, give me 4 types of security agreements under the MPSR. Any 4 types of security agreements?
Types of security right.
Security agreements, the security agreements.
Oh, I think I can't really recall. I'll just need the guidance of that.
Okay, no worries, that's fine. List for me 3 types of, or give me 3 examples of duties of a director. Just 3 duties of a director of a company.
Okay. Can you hear me?
Yes, I can hear you.
Okay. The duties of a director. First of all, a director is mandated to carry official business of the company, and these duties are outlined in section 140 to 147 of the Company Act. And some of the duties of a director is to act within his powers. If he goes against such powers, he can be held accountable for that. Also, the director has a duty to avoid conflict of interest. That is, he should balance whatever interest the company has and his own personal interest. He also has a duty to exercise independent judgment so that whatever decision he has to make, he must have a sober mind and make that decision by his own judgment. Thank you.
Thank you for that. Now, my last question is on the field of legal writing. Give me 5 qualities of proper or good legal writing.
Okay, thank you for the question. Legal writing the first quality of a legal writing, that it should be simple to be understood by even a lay person. Another quality of a good legal writing is in case of doing a case summary or a case brief, you're supposed to follow the IRAC rule, and that is you're supposed to highlight the issues, the rule of law, the analysis, and then you make your conclusion. And then another principle is that legal writing should avoid verbosity. And another quality of legal writing, it's supposed to be precise and direct to the point. Yes, that's all I can give.
And so they come to girls, they get married, they get pregnant.
Please, okay, that's fine, that's fine. He's muted. Are you done, Ogola?
Yes, did you lose me at any point?
No, I didn't lose you at any point. That's totally fine. Okay, you've done extremely well. There's huge improvement because I remember you're one of those who used to participate in the previous one. There's great improvement, and I'll give you my comments after Noah asks his questions. But personally, you did extremely well for me. You did well for me. Noah, please go on. But it seems Noah is a bit indisposed, so maybe I can take Ogola through some of the answers. So I asked the first question on principles of sentencing. So you got them right. You were a bit skeptical or afraid to answer in the first place, but you actually got them right. So you need principles of sentencing are, there has to be proportionality when you're sentencing. There has to be equality/uniformity during sentencing. So, you cannot give people who are charged with the same offense, and everything is so similar. Give one person 10 years and another person give another person 15 years. And yet the case before you was similar, in facts and any other matter. So equality and uniformity is a good aspect when it comes to principles of sentencing. There has to be accountability/transparency, meaning there has to be reasoning in the judgment. There has to be proper reasoning in the judgment. And you can check section 169 of the Criminal Procedure Code. The other aspect of sentencing is inclusivity. So currently we have victims participating in sentencing, so they have the right to be heard. So there is the issues of, you've heard of victim impact statements. You can check the VPA Act, the victim, the VPA on issues of victim impact statements, under section 12 of the VPA. Okay. And then we have, I think those are it. Proportionality, uniformity, accountability, transparency, inclusivity, and also, yeah, that's just it. Now, on the issue of practicing certificate, you also got it very correctly. The only bit that you stumbled kidogo was on the case law. And you can check, when you asked about the locus classicus case laws, you can check the case of Anajwea Housing and also Wilson Dolwaya, distinguish between both cases. The statutory framework for the same is the Advocates Act. The Advocates Act under section 19, which now gives the requirements for you to practice as an advocate. You need to have a valid practicing certificate, you've been entered into the role of advocate, and you've been admitted as an advocate. And you can also check section 34B of the Advocates Act. It talks on the issue of practicing certificates. And also lastly, the SOPIC, Standards of Professional Practice and Ethical Conduct. To be specific, SOPIC number 1. You can check SOPIC 1 of the SOPIC 1 of the Standards of Professional Practice and Ethical Conduct. Now, the next question that I asked was the types of security agreements under the movable property security rights under that topic. So if you check Section 4 of the Movable Property Security Rights Act, it gives the types of security agreements that you can enter. The types of security agreements that you can enter into. And that was what I was asking. And it's actually a question that is commonly tested in exams. When we start doing our past papers, I will show you how they ask those types of how they bring out the issue of Section 4 into the exam. So you can check Section 4 to be specific, Section 4.1, Section 4.1b, and they're listed there. There's a chattel mortgage. You've heard of the chattel mortgage. There are credit purchase transactions. There is a trust indenture. There's a pledge. What else? A financial lease, a floating charge, a fixed charge, and so forth. Those are the different types of security agreements that you can enter into pursuant to the MPSR. The statutory provision for it being Section 4 of the MPSR Act. Now, the next question I asked, you answered it very well. That was on the duties of directors. There's no need to go through it. Just read Section 146 of the Companies Act going forward. Qualities of legal writing, you did it very well. There's no need to belabor much about it, on that. So you did perfectly well. And unless you have questions for me, you scored well. Unless you have any question.
Thank you. I have no question.
No problem. Now, on the types of security agreements, I don't know if I should tell you, but explain individually, but we can do it the next time when, let's say, maybe we can spare the last 1 hour to go through the Movable Property Security Rights Act. From when, what is a movable asset in the first place? Why do we have the MPSR Act in the first place? How is a security created pursuant to the MPSR? What is a notice? You've heard of notices, initial notice. What is an initial notice? What are the effects of registration? Orders of priority rights? And issues to do with transfer and enforcement of security rights. So don't worry, it's a broad topic, but we'll go through it over time. So I'll be glad. So no, is Noah in?
So, sorry for the interruption, Solonka. You've
Yes.
forgotten one question. You asked qualities of good legal writing.
Oh, okay. The qualities of good legal writing. It's because he answered them. Okay, the qualities of good legal writing is, avoiding legalese, proper punctuation, proper grammar. What else? They are endless. Short sentences, being, certainty, going straight to the point, clarity, and so forth. Those are the qualities of good legal writing. Those require very, very straightforward. Is that fine?
Yeah, it's fine.
Yeah, because they were a bit simple, so that's why I didn't go into it very much. But your clarity, you have avoid legalese, proper punctuation. You have to be simple. Short sentences. What else? Whatever good thing you can think about legal writing, put it there. And there's actually a case law on that, if you can be asked. Because I remember, okay, I have this habit where I have to read maybe a case. I have to read one case every 2 days. And there's a case I came across. I'll get it to you and then I will send it to the group. It involved the Judicial Service Commission and one of the deputy registrars. And in that case, issues of legal writing came about because the advocate for the deputy registrar who was unfairly terminated filed an affidavit that had over, how many? It had so many paragraphs. It was a very lengthy affidavit. The proceedings were so lengthy, and Justice Kiagi was there blasting that advocate, and he just said that his drafting is a good example of what not to write when it comes to legal writing. It's an example of what poor drafting is. I will get that judgment. You could use it when you're talking about legal writing and so forth. But yeah, that's all. Ogola. Now, Kevo, Robert, Kelvin, since Noah is not in, Lavis is texting me. He's
Mr. Solonga,
no, you're in. Okay, sir. Tulikupoteza kidogo. But okay, you could start questioning because Ogola is done. You could start to question Robert, and then I'll follow up with my questions, then we'll give him his comments. Robert's hand is up.
Mr. Robert. Mr. Robert, are you there?
Yes, yes, sir. Sorry, I had issues to unmute, but yes, I am here, and I'm glad to be here.
Okay. Good evening, sir.
Good evening, my senior.
Okay. So I have a couple of questions for you. Now, my first question is, what do you understand by the term preemption rights?
Thank you, Noah, for that question. Preemption rights. Well, I will just make a try about preemption rights. Well, I think these are the rights which you need to serve to the other party, which you need to expressly state them to the other party in a transaction.
Okay. So my second question, how do you institute divorce proceedings?
Thank you, Noah. So, you institute divorce proceedings through a petition. For you to approach the court through a petition, it needs to be expressly provided for that this is how you shall approach the court. But it is provided that you approach the court through a petition in divorce proceedings.
Okay. My third question, do you know what discovery under civil procedure is?
I can make an attempt, and discovery comes in the initial stages while you are preparing for a case, and discovery entails knowing or coming to be aware of what the other side, the documents which are in possession of the other side, and the documents which the other side will be relying on in their case. So you shall be making an application to know what documents they possess and what documents they intend to use during their case.
Okay, my last question, it's a campus question under criminal law. Do you know the principle called the three-strike principle?
Unfortunately, no, I'm not aware of the three-strike principle.
Okay, that's all. You have answered the question. Let Solonka ask you a certain question, then I'll make my comment.
How are you, Robert?
Fine, thank you, Solonka.
It's good to have you here. Okay, what's your understanding on actus reus? What's actus reus and how is it different from mens rea?
Thank you, bro. So I understand actus reus to be the state of the mind just before committing a crime. Mens rea is what will generally define as a guilty mind. This is the state of the mind which comes up with the idea of committing a crime. And it is different from actus reus in that actus reus is the act or omission which brings about the crime, while the mens rea is the state of the mind, or what I basically call a guilty mind. Now you realize that in some offenses, you will be required to prove both mens rea and actus reus, while in
Yeah.
some offenses you are only required to prove the actus reus. Example of offenses where you are only required to prove the actus reus is in manslaughter, is compared to murder, where you have to prove both mens rea and actus reus.
Thank you for that. Thank you. What are the rights of an accused person? List for me the rights of an accused person.
Thank you so much, Solonka. So the rights of an accused person are provided for in Article 49 of the Constitution, and they are quite lengthy, and I can take you through a few of them. Number one is when an arrested person has been arrested, he has the right to be informed of the offense which he has committed. An accused person has the right to seek legal advice from an advocate or from his lawyer. An accused person has the right an accused person has the right to be arraigned before court within 24 hours of his arrest, and he has the right um, to be accorded enough time to prepare himself for the trial. He also has a right to communicate with his people so that he can be able to it can be able to be able to secure the bail or the bond which should secure his release pending trial.
Okay. Okay. Now, my final question be a problem, not a problem question, but okay, it's just a question. Now, you you are a director of a company, and that company had passed resolutions. How would you circulate those resolutions? In simple terms, what are the forms in which, or the ways in which you can circulate written resolutions that have been proposed?
Thank you so much for that question. So when it comes to passing or circulating resolutions which have been passed by a company, first of all, it is prudent to begin by saying that we have two types of resolution. You can have an ordinary resolution or a special resolution. An ordinary resolution is the one which is passed by a simple majority, while a special resolution is passed by 75% of the members. Now, once this resolution has been passed, the directors of the company can circulate these resolutions through various ways. One of the ways is through using postal address. They can send this resolution to the address provided for each shareholder.
Correct.
Alternatively, the directors can post this resolution in the company's website where eh, members of the public or the shareholders can be able to view the
Yeah.
resolution. The directors can also choose to pass through this resolution through a newsletter which will be circulated to all the shareholders, or they can post the resolutions in a newspaper with countrywide circulation.
Okay. Yeah, that's great. That's great. You answered my questions very well. Yeah, you did exceptionally well. Now, the only thing I'll do is give the statutory provisions for the same for those questions that I've just asked. On the issue of circulation of resolutions that have been proposed made by directors, you can check section 265 of the Companies Act. So what you listed, hard copy, website, or in electronic form. You got it perfectly. The others, I don't think there's any area I need to clarify. You nailed it. You nailed it on my end. Now Noah maybe can give his feedback or comments. No, are you in? No.
Mr. Solonga.
Uh-huh.
Yes, I'm in.
Oh, you're in.
So,
Okay.
am I not clear?
No, you're clear. You're clear right now.
Okay.
It's fine.
So my comment. So my comments are. Okay. So my first question I asked about preemption rights. I'll refer you to section 338 of the Companies Act. So what happens whenever a company allots new shares? Basically, they must first offer them those shares to the existing shareholders. So the existing shareholders always have the first right over those new allotted shares. So before they go to the new members, they have to go through the existing shareholders. So basically, that's what preemption rights is all about, Mr. Robert. Then my second question, I asked about divorce proceedings. You answered it correctly. It's usually via petition, and the normal grounds are adultery. We also have cruelty, and then we also have another ground that one can file a petition is desertion for at least 3 years, and lastly, exceptional depravity. So you have to file a petition to court, you are correct. You must also outline the grounds under which you are seeking divorce. So that petition must be made at least 1 year after the celebration of the marriage. So you file that petition after 1 year. You cannot file it before, maybe you got married today, then tomorrow you want to file a divorce. No, that marriage must be given a year, lifespan of a year. So it must be accompanied by a verifying affidavit and a notice to appear. So, and then lastly, I asked you about the 3-strike principle. So the 3-strike principle, Mr. Robert, under criminal law, this is usually applied, it normally applies to these problematic individuals. So it basically increases sentencing of persons who had earlier been, who has been convicted of a felony, and the same person has previously been convicted of 2 or more violent crimes. So basically, the 3rd strike is where now the court has an option of increasing your sentencing to, the sentences. So normally it applies to these problematic individuals who mostly commit crime. Mapata leo wamefanya crime, then maybe wamesamehewa, then the following day wakafanya tena, wamesamehewa. So the 3rd time they are committing this crime, then the court has to increase now the sentences. So basically that's what the 3 strikes principle is all about. I'm happy how you answered it. You did not pass. Ukubali swali kupite, which is also good. So yeah, that's all. Those are my comments to you, Robert.
Okay, thank you, Robert. Thank you, Robert. Who else now? Thank you, Noah. Thank you, Robert, also. Unless, do you have a question for us, Robert?
Solonga.
Yeah.
Before you proceed, under usually divorce proceedings, is it worth mentioning here that you can only institute a divorce proceeding after you've been married for 6 months? It's not allowed earlier. And then also, when talking about the 3-strike principle, isn't it also necessary to mention where it comes in law or in the court? And I think where it comes in, Lizanga, has the accused been charged before? And if so, if the accused has been charged before, then the previous charges are read. I thought it is necessary to add that.
Thank you for that. Thank you for that, Wanyama. Yeah, that's very true. On the issue of 6 months, please give me the statutory provision because I won't even lie. I didn't. Okay, things to do with family matters usually hate me, but it's something at least I have learned, and I appreciate learning it from you. Thank you very much for that. On the issue,
maybe I'll just text in the group. I don't remember the specific provision, but I remember Nani telling us, and Ratemo is actually the one who mentioned it, despite the fact that he was taking us through constitutional law.
Oh, Dr. Ratemo, okay, thank you so much for that. I really appreciate that. On the other issue of still strike, yes.
1 year.
Huh?
Sorry for the interruption. Veronica, you've said 6 months of the celebration of marriage, and Noah said 1 year.
I'm saying, Miss Veronica, thank you. I'll also
You're both muted. Noah, please go on. Okay, there's some mishap somewhere. Okay, now there are actually 4 hands raised. So I saw Mwangi raised his hand first, then Kimani Esther, then Gasheru, then Nyabio, in that order. So thank you so much. I've actually not read it. I don't keep like a chini, I'll just name you and call you. So Mwangi, are you ready?
Evening to you, Brian, and evening to my esteemed colleagues and Noah as well. Mine is not to volunteer myself for questioning. I just had a few questions based on the prevailing discussions. So the first set of questions involve the mechanics of like answering questions, and I just wanted to clarify a few things. And I'm not sure if if you have spoken about this in a different session. But all the same, I would be happy if you would clarify. So the first thing I'm curious about is so when you're asked a question you don't know the answer to. I have been seeing my esteemed colleagues either passing or making a guess. So I'm wondering, what would you advise in that regard? Two, I have also noticed, based on today's session, and I think the session last week, there is a practice among my esteemed colleagues to thank the panel for the questions that they have asked. So I'm curious, if at all I, for lack of a better way of expressing this, don't want to thank the panel, is that bad form?
No.
And then maybe the whole yes, so just those two, and then maybe I could ask a follow-up question on this whole idea of allotment versus an allotment.
Okay, no problem. So, okay, on the issue of, I think it's prudent, maybe even so that moving forward, the guys who we will ask questions, maybe can follow that. So when you're asked a question that you don't know, the first thing you ask yourself, do you know at least something small on this? At least something small. Or you don't have any clue or any idea with regard to that question. So you need to ask yourself, you need to, on your feet there, within those few seconds, do I know something small? Don't I know something, or don't I know anything about in this topic? And I'll give an example. I was asked, of all the questions that I was asked in my panel, the one that got me the most was the one that I asked Veronica, and it actually got her, was the issue of Article 10. I was told, give us the principles under Article 10. At that time, you're tensed and you're panicked. You can't remember them very well. But what I did is I remembered a few aspects, and actually remembered two main things. I remembered sustainable development and the issues of intergenerational equity and rule of law. And that's what I used to answer that question. So I said Article 10 talks about national values and principles of governance, and then proceeded to give the small that I understood on that topic. That's because I had a light clue on it. But there are questions where you will be you know, a lecturer can come before you and then ask you, for instance, that case of Republic versus Mongo. You have no idea what the case talks about. You don't know about the case. You've never heard about the case, and you generally just don't know anything pertaining to that case or whatever principles that the case established. So in that circumstance, you wouldn't start guessing. You know, you just can't guess from nowhere. The guessing has to be smart to some extent. So my advice is, if you have a clue, attempt. It's not very good to pass questions, because there are some lecturers who, when you pass those questions, it affects a point where they will now ask you, okay, now tell us an area of law or which unit you want us to question you from. And then, you know, you think on your future and you're like, probate is very easy. So you give them probate. Now when you give them probate, you get a much more harder question. And passing, there's that kind of impression it creates on the lecturer that you're not prepared. So in as much as possible, as a lawyer, even me, there are some questions you will ask me and I will try to attempt it. And then, you know, tell you I'll go do research later on and come back or inform myself properly to this particular question. But just passing or saying I don't know, as a lawyer, it's not so good. And even when you're appearing before your lecturer, it's not so good. At least try to attempt if you have an idea about. But if, in all honesty, you don't know anything about that subject or about that topic, you could just pass. You could just pass. And when you pass a question, it doesn't necessarily mean you will fail. Because I have friends of mine who passed around, you know, 2 questions, and they ended up getting 17s and 18s going up. So don't fear passing. If you don't have a clue, it's true. You don't know everything. So if you don't have a clue at all, pass. But if you have some idea, answer. You just give that small you have. You attempt. Now, on the other issue of thanking the panel, it's not a must if you don't want to thank them. Just seems maybe polite and all. But necessarily, it's not a must. When I was asked the questions, there were circumstances I would say thank you for the question. But then in between, you don't even have time. You know, the questions keep coming, they keep coming. It's not a must for you to say thank you. Know, it's not a must for you to thank the panel every now and then. And you actually have to read the room. There's some lecturers who will maybe get pissed off on that. So, you know, it's more or less repetitive. So it depends. You just need to read the panel, read the room. If the lecturers, you know, based on previous experience, or maybe you had colleagues who went before them in the morning, or 2 colleagues went before them, you could ask them and then get to know what each particular lecturer wants. For me, I met who was this lecturer? Miss Kiguada and Dr. Oriri. I only said thank you for the first question. I think for the first question. And the questions kept coming. So I just went straight ahead and I gave them the answers to those questions. I went straight ahead and I gave them the answers to those questions without even thanking them beforehand. Now, and this is another thing that I've just remembered. When a lecturer corrects you, take it positively and just take it positively. So I remember there was a question I was asked pertaining escrow accounts when it comes to conveyancing. The lecturer, so yes, she asked a question and I said, the way to go about this particular transaction is by having an escrow account and the purchaser and the vendor to deposit that account, to deposit the purchaser to deposit the sum of money into that escrow account. Then afterwards, after I finished answering, Ms. Kiguada, not necessarily corrected, but gave a few additions to it. And I just responded, I said, I stand guided on that. I will do more research on it, and so forth. And I still ended up passing because I had 19. They corrected me in that one particular question and maybe another particular question. Yeah, there were 2 questions in which I was not necessarily corrected, but they added something small. It doesn't necessarily mean you'd fail. So if, let's say, you've been asked one question and then they correct you on that question, don't lose sight. Answer the remaining questions perfectly and take it positively, because you'll still pass. So yeah, that's it. Those are the
if I could ask a follow-up on the issue of passing. So how do you pass the question in a dignified way, or quote unquote. Yeah, because I noticed in a previous session, well, my assumption here is that saying pass looks bad, but I've noticed in previous sessions, my esteemed colleagues saying things along of I'm still learning, so I'm just looking for something along what we would say is most acceptable or most dignified, quote unquote.
Okay, that's fine. Don't just say pass. You're not going to be asked a question, like, for example, what is a preemption? What are preemption rights? Pass. What was the rationale or the ratio decidenda in the case of Republic versus Mango? Pass. No, you don't say pass. So first of all, you need to play it. You need to play smart hapo. You need to ask yourself, have you been taught this thing in class? Maybe you've been asked a question on preemption rights and you've not covered company law. You could tell the lecturer, I'm sorry, but we've not covered that topic yet, but I promise to engage and do more research on it so that I may become well informed on that particular concept. That's a good thing. So you may tell the lecturer that you've not covered it if you haven't covered it. And if maybe you've covered it and you cannot recall, you can just tell the lecturer, I'll do more research on the same. I am not well informed right now, but I promise once I'm out, I'll go do more research to inform myself better on that topic. That's how you could do it. But don't just pass. There's no standard way, but just you can have a way to dignify it, as you've put.
Yeah, thank you so much. Apologies for taking the spotlight for a bit here. Apologies to my esteemed colleagues, but one final substantial question, and maybe this I could direct to Noah, as at the point when shares, or you as well, as at the point when shares are being, when you're deciding like the amount of capital that is going to represent the value, well, the amount of capital that is going to form the basis of the company, on what basis do you base that capital based on? I don't know if that question makes sense. So that then you can allot, so you can have then shares that are allotted and the ones that are unallotted. So I'm asking the initial share capital as that should register at the point of registration of your company. How do you decide that figure? Is it backed by any value or is it arbitrary?
Mr. John, could you please, Solanka.
Yeah. So I think, John, in simple terms, you're asking, how do you determine the value of your shares when you're forming a company?
Yes.
If I can get you right.
Yes.
So it totally depends on the parties. You can have, when you're forming a shares, how many shares do you have in that company? Or how many shares do you have in that company, and what's the share capital of those of that, what's the share capital of that company, and how many shares do you have in that company? So share capital is the capital of a company. It's just the capital of a company that comes from the issues of shares. Yeah. So you can have maybe one share representing the value of 100. Parties can decide so. And how do they decide so? So it's simple. Ogola and Adede and Ogola, Odede, and Noah want to form a company. You want to form a company, and what is the share? Ogola has been, okay, each of you have contributed how much? Each of you have contributed, let's give we've contributed each 1,000 shillings. 1,000, 1,000, and 1,000. Yeah. Now, from those 1,000 shillings, you each get how many shares? It's a 10 shares each. 10, 10, 10. What will be the nominal value of each share? Just take 1,000 divided by 10. So one share equals to what? Equals to 100 shillings. So the answer to that, the long answer short, from all I've said, or from all what I've said, is depends on the parties. What capital has been contributed to what capital has been contributed by the founders of the company that have been subscribed or in the memorandum? What is the share capital of the company? What are the issued shares in the company, then you just divide to get the nominal value. So in that circumstance, Ogola, Odede, and Noah, you've contributed each 1,000 shillings. Well, let's say we've contributed 100 shillings each, and for each 100 shillings, you each get one share in that company. So you will have your share capital. What will be the share capital? The share capital will be the total sum of the amount you've contributed. So it's 100 times 3. That's your share capital, 300 for the company. Now the nominal value for each share is you contributed 1,000, contributed 100, and you got one share. Meaning the value of a share in that company is one share equals to 100 shillings. I think that's the law. Have I answered your question on how it's obtained?
Yeah.
I know
you're saying. Apologies. Go ahead.
Sorry. Maybe we can go on.
Yes, it's fine. Thank you.
It's fine. Okay. And Noah talked about the issue of preemption rights. In simple terms, I think that thing is in your course outline. Preemption rights refer to the issue of first refusal, the right to first refusal. And I will use the same example. You, Ogola, you, Odede, and you, Noah. You are in a company. Yeah. Now, whenever the directors want to allot equity securities are just ordinary shares. Whenever a company wants to allot equity securities, meaning this company wants to issue out ordinary shares, and for what reason? Maybe they want to raise funds. So you have company X, you have a company, Ogola, Odede, and Noah. You have a company, you each have your shares. You have how many shares? You have one share each. Each of you have one share. And the company wants to allocate or bring in more members, because you see, once you're given a share and you meet some other formalities, you become a member of the company. Now the company wants to issue out, by the company I'm talking of directors of the company, they want to issue out 10 more shares. So the shares could be divided into one each, whereby one member whereby you can have each 10 more people coming in holding one share. You can, trial design, you can have 2 people coming in and they each hold 5 shares each. So the right of first refusal says in simple terms, or the issue of preemption rights, what the doctrine of preemption rights talks about is, before these shares are issued out, before these shares are issued out to members outside the company, they first have to be given to Ogola, Odede, and Noah. The right of first refusal. So the company needs to offer it first to the current shareholders, and these current shareholders have 2 choices. They can elect whether to buy or not. And then if they elect to buy, the company sells it to them. Now Ogola can maybe now add his shareholding to be maybe 2, 3. So you have maybe 3 shares, 4 shares. Ogola can add maybe 1 share and so forth. But if they refuse, then the company can now give it out or allot those equity securities to persons outside the company. That is the entire concept of preemption rights. Now, when it comes to preemption rights, there are certain factors that come into play. There's the issue of disapplication of preemption rights and exclusion of preemption rights. It's a topic that maybe we will cover another time, but the starting point is Section 338 of the Companies Act, the concept of right of first refusal. Before a company issues out shares to other members outside the company, issues shares to other members outside that company, they first need to allot or give the opportunity to buy or not to buy to the current shareholders. So they have to elect, do they want it or don't, or do they want to, for it to be sold to the other members of the public. So is that clear, Mwangi? Or maybe anyone else? But we'll do it later on. when you're talking about preemption. I'll put it also in the checklist. Preemption rights, disapplication and exclusion of preemption rights. But the starting point is section 338 of the Companies Act.
Perfectly. No, thank you so much.
Okay, no problem. But now I'll ask you a few questions, if you don't mind. Just 2-3 questions. There's 2-3 questions before you go on.
Yeah, I mean, sure. Might I suggest addressing the questions, or rather the guys who have their hands up, before subjecting me to...
No problem, but we'll come back to you. It's fine, it's fine. Okay, Gasheru, please go on. Oh no, it was Kimani, then Gasheru, then Nyabio. So Esther, please go on. I'd like to ask you questions. Are you prepared?
Is anyone ever prepared?
Don't worry.
But I am ready to proceed.
Okay. They're actually fair.
Okay.
Let's begin with what is a representative suit?
Sorry?
What is a representative suit?
Okay. A representative suit under the civil procedure rules is a suit that is filed whenever, for instance, there is a number of people who have suffered injury, but instead of all of them going to court, one person decides to file a plea or the petition or the suit on their stead or on their behalf, but they're all named or they all become beneficiaries when it comes to the remedies that they will be allocated by the courts. Yeah.
Okay, thank you for that. Now, what is the difference between special damages and monetary and special? I'm giving you the answer. Special damages and general damages.
Okay. When it comes to special damages, they are monetary in value, where the plaintiff decides or quantifies the amount of damages that he would like reimbursed to them after they have suffered the injury that they have. So for instance, if it's an accident claim, they will monetize probably the amount of money they used in the hospital. If it's 120,000, the amount of money that they used when it came to recuperation or therapy, such and such. When it comes to general damages are not monetized in value. It is what the court would find pleasing or what the court would find fair or just to allocate to the plaintiff. Yes.
Okay. Yeah, that's fine. Now, have you been taught company law or company procedures?
Not yet. We haven't got to company law procedures yet.
You've not done anything pertaining companies at all, yes?
Not. No, we have not.
Okay. Are you confident to try a question on companies? On the aspect of company law?
I would like to try.
Okay. Are you familiar with types of meetings in a company?
I would like to try.
Types of meetings. Yes.
So there are general meetings, annual general meetings,
yes,
where they are held annually or once every year, and they are called upon by the company, the directors of the company, to shareholders specifically, where they discuss all matters pertaining to the company's financial year, previous company's financial year, as well as the decisions that have been made. Then there are special meetings that are called upon by directors to discuss specific matters for contemplation. For instance, when it comes to winding up a company, then a special meeting would be called. But I stand guided on that matter. Yes, I think so far those are the two that I can comfortably remember.
Okay, that's fine. Now, my next question will be on professional ethics. Let's go to I haven't asked it. Okay, I've asked a question, but okay, my next question will be on professional ethics. Advertisement. Can advocates advertise?
I'm wondering.
Did you get me well? Sorry, I think the network.
Someone moved me from the meeting actually.
Sorry about that. Can you hear me now?
Yes, I can.
Okay, so I was asking. Okay, I'll give you a question in the unit known as professional ethics, and my question is: can advocates advertise? Support your answer.
Can advocates advertise?
Yes.
Yes, they can, and pursuant to the advocates' marketing and advertising rules. They can only advertise pursuant to the specific rules that have been set out in the advocates' marketing and advertising rules.
Okay. Okay. Sawa. Now, I'll still ask a question on professional ethics. Now, I want you to give me at least two instances of where conflict of interest arise, and give me a statutory backing for it.
Okay, conflict of interest. These when it comes to conflict of interest, it is provided for one under the Advocates Act and also under the SOPEC 9 specifically, and instances where conflict of interest may arise under SOPEC 9 is one where the advocate faces an instance where they just give me a minute. I think
it's okay, take your time. I asked them.
Hi, I'm sorry.
Thank you so much. Are you done?
Huh?
Are you done?
No. Just. Oh God. I think I can. Can I be?
I think we lost Esther.
Yes, I'm here.
Oh, it's okay. So I'm done asking. I give you my comments, but Lavins is actually in the meeting and he's been there for almost an hour, but he hasn't been talking. So let me invite Lavins to ask you a few questions. Then now we proceed.
Okay.
Lavins, are you in? Hello? Okay, as Lavin students, you did perfectly well for my questions. You've answered well. You've given statutory provisions for the same. Maybe I can give you my feedback before Lavin starts. Because I apparently is in the meeting, but
So long as I'm here.
Okay. So you could ask Esther questions and I can both give her feedback. But so far for me, she's done very well. Impressed.
Right. Greetings everyone. Sorry, I've been away, but I've been following up for the last 1 hour. So perhaps the little time that's remaining, I'll make good use of it. So the first question, could you kindly tell me or give me 3 differences between an advisory and an advisory opinion? Just 3 differences.
Sorry?
I'm saying, could you kindly give me 3 differences between an advisory and an advisory opinion?
Okay. An advisory opinion is provided for, is the prerogative of the Supreme Court, where they, or it provides, I don't use the same term. It provides advice when it comes to constitutional matters or constitutional interpretation matters brought forth by any person. It could be a citizen or also a member of the legislative body or the executive, but basically it's the Supreme Court's prerogative to provide interpretation or advisory opinions with regards to interpretation of the Constitution. When it comes to advisory, I would base it on the powers vested on both advocates and the court to provide. No, actually, I would just give it to the advocates themselves to provide advice to their clients. But I would stand guided on that particular matter.
Okay, what are the 2 perhaps advisory opinions that the Supreme Court of the Republic of Kenya has rendered this far as the apex court? I repeat, what are the 2 perhaps, just they've given quite a number of advisory opinions, but I only need 2. Just 2 advisory opinions.
I would think there's one that I would think from the top of my head. There is one that was done recently but I haven't yet got to it. The Speaker of the County of the Nairobi County Assembly versus the AG. It's a 2021 case, but I haven't really interacted with it. I actually just recently got to find out about it. So far, then there's yeah. I think let me stick with that one. Let me not say another one that I am not really sure of.
So the other question is, are advisory opinions binding? Are they binding? Yes or no?
No. I would, yeah.
Away from advisories and advisory opinions, I want to enforce professional undertaking in the high. I want to enforce a professional undertaking in the High Court. What pleadings will I file?
You want to enforce professional undertakings in the High Court.
What pleadings would I file?
Since it's a professional undertaking, I would think you under the civil procedure rules, you would file I think I would stand guided on that.
Right. Thanks.
Thank you.
Solonka, I don't know how you want me to proceed. Perhaps give up of this and maybe ask the next person, other questions.
Oh, okay. So you're done asking extra questions, huh?
Yes, I am. Thanks.
Oh, it's okay. Now you can maybe give her my feedback. So for me, she answered my questions very well. The first question was on what is a representative suit, and she answered it well. She mentioned the civil procedure rules, the 1 Rule 8 to be specific. And this is where you see you have parties with a similar cause of action and they're asking for the same reliefs. They can have one or more plaintiffs to sue on their behalf. Yeah, so they represent them. That's a representative suit. Statutory backing is Order 1, Rule 8 of the Civil Procedure Rules. The other question that I asked her was on advertisements. Now she got it. Very well. She got it correctly. So can advocates advertise? The answer is yes. The locus classicus case for that is John Okeo Omwanza versus the AG, which declared Rule 2 of the Advocates Marketing Rules, which prohibited advertisement, as unconstitutional. So it was declared unconstitutional. And you can check the Advocates Marketing Rules, the one that she referred to, and advertising is allowed. You can put your academic qualifications, your name, your years of experience, and so forth. But the things that you cannot do is, for instance, put your name on a billboard. Issues to do with contingency agreements, you cannot do such things. And even matters pertaining to radio advertisement and so forth. The other question that I asked was on conflict of interest. She did very well. She mentioned SOPEC, Standards of Professional Practice and Ethical Conduct. The provision for it is SOPEC 6 of the Standards of Professional Practice and Ethical Conduct. There are so many case laws there. You can begin with the classic case of King Woolen Mills versus Kaplan and Stratton. You can also go ahead and check Rule 8 of the Advocates Practice Rules. This one talks about where an advocate may appear as a potential witness. And there's a case on that, Francis Mugo versus James Mothe. If you're going to be a potential witness in a certain case, then you should not take up that matter because of issues pertaining to conflict of interest under SOPEC 6. And also Rule 8 of the Advocates Practice Rules. And then the last one would be there's this principle. There's a UN basic principles in the role of lawyers. You could also cite that. It has the basic principles that should guide lawyers, and that's actually it. Was there a question that I've left? I feel like there's one particular question that I've left out, but I can't remember. Is there a question that I've left or that I asked her and maybe I've not given my comments on?
The one on company types of meetings.
Hello, I can't hear you. Come again.
It was on company law types of meetings.
Yes. I asked you the types of meetings of companies. So you got it right. You mentioned the AGM. So I could classify them as, I could put them as 4. There's class meetings. There's class meetings. Now class meetings, these are the meetings that are held by different classes of shareholders. So we have ordinary shares, we have preferential shares, we have employee shares, and so forth. So there are different classes of shares. We'll come to do it later on because it's a topic on its own on shareholding of companies. So each share, there are different shareholders. So class meetings are the meetings of the different classes to discuss maybe issues pertaining to their specific shares, because the rights that preferential shares have are different from the rights that ordinary shares have, and so forth. So that's one type of meeting, class meetings. There's an annual general meeting, you got it very well. It's held in each year, and it shouldn't be more than 15 months between the date of the last meeting. So it's held every year. The AGM is usually held every year by a company. The other meeting would be extraordinary general meeting, an extraordinary general meeting. So this one is convened at any time. The directors can convene it at their own motion, or the members can do it or requisition the directors to hold such a meeting if those members represent a tenth of the paid up share capital. A tenth of the paid up share capital. So the issue is, if those members represent a tenth of the paid up share capital, you can have one member who's representing a tenth and he can requisition for the same. You can have, and so forth. You get the idea behind it. And then the last one was statutory meetings. So statutory meetings, these are meetings that are held by public companies only, and it is usually done 1 month and not more than 3 months after the company commences business. Statutory meetings. So those are the different types of meetings. Other than that, I'll leave the floor to my colleague Lavins to give his comments, then now we can proceed.
Thank you, Senior. So just feedback on the questions I asked. The first question is about what's the difference, or what's the discrepancy between an advisory and an advisory opinion. So it's very simple. An advisory is a recommendation, whereas an advisory opinion, it involves interpretation of the law. For this question, I wanted to limit you to the apex court of the Republic, which is the Supreme Court. So I wanted to know, do you really understand how the two are distinct of each other? So an advisory is always given by the Chief Justice unilaterally. When you look at Article 261, sub-article 7 of the Constitution, it limits the Chief Justice. And an advisory, is given by the Chief Justice based perhaps, on a dissolution of Parliament, like he did, before, he was derobed. And then an advisory opinion is the entire setup or the entire bench of the Supreme Court, of the Republic, the 7-judge bench. Then the other difference is an advisory, is not necessarily, meant to quote unquote bind. Okay, it's only given by the president of the Supreme Court because it is based on perhaps non-compliance of the Constitution. For example, the gender, the gender rule. Yeah, so those are the kind of things that I wanted you to perhaps, apply in your response. And then the other question that I asked you, is an advisory opinion binding. You see, well, there are those who are pro this, there are those who don't support, the binding nature of advisory opinion. But yes, they do. When you look at Article 163 or Article 163 sub Article 6, of the Constitution of Kenya 2010, it basically gives the Supreme Court that power. So it could be obtained either a state agency, the power state or anybody that serves to distinguish its functions from the other. And then this now will lead me to the other question that I asked you. Give me at least 2 examples of advisory opinions that the apex court has rendered thus far. So there's one that was in the matter of the principle of the gender representation in the National Assembly and the Senate. This was a 2012 advisory opinion given by the Supreme Court. And then the other one was the distinct functions between the National Land Commission and the Ministry of Lands and Physical Planning. You can also talk about the other advisory opinion that that the apex court rendered, which was the speakers of the 47 county assemblies, versus the Commission on Implementation of the Constitution and 2 others. That was a 2016 advisory opinion. And yeah, so you have to know at least two of these advisory opinions, because they're always asked, I won't lie. The other question that I asked you was about a PU. I want to enforce a PU in the High Court. What pleadings would I file? So an application for an order, for the enforcement of an undertaking, given by an advocate, shall be made in 2 instances. The first instance, if the undertaking was actually given in a suit, in the High Court, the application will be made by summons in chambers, in that particular suit. So that's a CS. The other instance, in any other case now, by OS in the High Court. So those are the only two instances under which one will be allowed to file an application for enforcement of a PU. And the court is the High Court. So you have a CS if it's within a pending suit, and you have, an OS, in any other case. I think those are the only questions I asked you. Yeah, so, yeah, fair enough. You're sharpen your iron, and you'll do well. Yeah, so, I think that's it.
Thank you so much. Esther, you did well. You did extremely well.
Thank you. I'm sorry for the noise though.
It's okay. We totally understand. Actually, I'm here with my brothers and they're making so much noise also. So, you understand. Now, I can see Gasheru has his hand up. But since Lavins hasn't had much time, Lavins could start this one off, and then Noah could also follow up after you. So you two can take it up with Gasheru.
All right. Gasheru, greetings.
Greetings, my brother. Habari ya leo?
Salama sana. Nashukuru Mola, labda za kwako.
Mimi pia niko salama.
Sure.
Yes, although my hand was up because I had a question. Maybe I can ask the question and then maybe you can proceed and ask the questions.
Okay. All right. No worries.
Okay, so my concern was on the land registrar. So is it really the position that the land registrar does not have the power to cancel a title deed? Because when I look at the provisions of the Land Act, they seem to suggest that there are those exceptional circumstances where the land registrar can cancel a title deed.
And now let's begin with those provisions. First of all, from what can I say? Okay, let's begin with those provisions first of all. Then I will proceed from that. Which section was that? That gives out the function, because I do believe he has a power. He has a power. But you see, the issue of cancellation is different from the issue of due process. Yeah. So you may have the power, but how you go about it makes it illegal. Yeah. How can I like for what instance? So you could check. Trying to recollect my mind on this. So you could check maybe the Fair Administrative Action Act. You could also check Article 47 of the Constitution. And I can give an example. So CBK, for example, the central bank has a right to do what? Has a right to, okay, the central bank oversees all banking transactions that happen in the country. Yeah. So let's say the central bank takes a particular course of action against a certain banking entity. Yeah. Do they have the power to do it? Yes, they do. But how did they go about it? Did they give this institution? Did they give them reasonable time to make representations? Were they heard, and so forth? The concept of natural justice and the concept of due process. The same case applies to the issues of land registrar. Before he cancels your title, he can't just wake up one day and decide to cancel your title. No, he has to call you, give you what's it called? Give you notice.
Yeah.
After giving you notice, you need to make your representations on the same. After you've made your representations, then a decision is made. That's perfectly fine. But if they don't follow that due process, then it becomes a problem. And I could direct you maybe to give you one particular, and just to bring it home. You could check the issues to do with the restraints in disposition of land, cautions, restrictions, and inhibitions. And I want the focus to be on restrictions, because restrictions are lodged by who? The registrar. So you make an application to the registrar to lodge a restriction. So your question here will be, does the registrar have a power to lodge a restriction over your property? yes, he does have the power to lodge a restriction over your property. The statutory provision is Section 78 of the Land Registration Act. Now, before the registrar lodges a restriction, what does he need to do? If we check the reading of that provision, he has to give notice before lodging that restriction. He has to go to the proprietor and give that proprietor notice that, you know, I am about to lodge a restriction on your piece of land because of this and this and this. Okay. Why does it give you that notice? To give you ample time to make your representations. After you've made your representations, he then makes a decision, you know, whether to lodge a restriction or not. The other thing is, after he has lodged a restriction, he also needs to give you notice that a restriction has been lodged. All those forms are in the legal notice number 270, the Land Registration General, the Land Registration Regulations, legal notice number 278 of 2017. They're all there. So the issue is not whether he can or not, or whether he can or whether he cannot, but the issue is, what did they follow that procedure? Yeah? And if you don't follow the procedure, there are various provisions you're going to be violating. You're going to be violating article, let's say if it's something to do with a particular piece of property, piece of land, what provisions can you think about? You're violating the first provision is Article 47, right to fair administrative action.
Okay. All right. Thank you.
I don't know who removed me from the meeting. That's funny. But yeah, okay, there are various provisions that are violated. There's Article 47, there's Article 40. You can talk about Article 73, that is usually very much abused under Chapter 6 of the Constitution, and so forth. So that's the question. That's the question. Not whether they can do or whether they can't, but it's geared towards what's the process that was followed.
Okay, thank you for that.
Okay, now I see who else has their hand up. There's Dan and there's Agoro. Now, Vince, you could ask Gasheru questions, and then now we'll proceed to Dancer, to Nyabio, and then Nyabio had a hand up first, then Agoro, Harriet, and then Dancer.
All right, thank you. Gasheru, you're hearing me, are you?
Yes, I'm.
Thank you. So my first question, what do you understand by the principle of audi alteram partem? And what's the provision of the Constitution of Kenya 2010 that supports that principle, or the doctrine of audi alteram partem?
Thank you very much for that question. So basically, in simpler terms, when we talk about this principle, it is, I think it's more of the fair, I can, put it together with the Article 47 on the fair administrative action. So basically what it means that you should allow the other party also to maybe present their case before maybe you can pass some judgments. Such that you do not have, basically, I think what I can say, it is a principle of, fair hearing, such that you do not make a decision while not giving the other party an opportunity to also present their case.
All right, thank you. My next question, the legal profession is not a business entity, but a profession dedicated to public service. So discuss this in support or lack thereof, just giving me two answers. In support or lack thereof. I'll repeat, the legal profession is not a business entity, but a profession dedicated to public service. So discuss this particular statement in support or lack thereof. Just two answers. I don't need much.
Okay, thank you. Number one, I can state that when it comes to a profession, like the definition of what a profession entails, there are those conditions that have to be met. So in my opinion, it is service to the public for the simple reason that where once one becomes an advocate, they go out there to serve the members of the public. So the first response is that the advocate owes a duty to the members of the public, which is very, very paramount. Then number two, you find that advocates are in a position whereby they ought to carry themselves in a way that does not, bring shame to the profession. So I think all this is geared towards, the belief that the public will always come first. Okay.
My last question. I have died intestate, okay? Yes. So my estate, is in contest. So, people have to survive. So there's a way now they want perhaps to take, custody or control of my estate. So what petition do you think will be filed? That's the first question. The second question, what documents will support this, particular petition?
Okay. Maybe if I have heard you correct, in the event that maybe the beneficiaries want to survive, you find that you can file a special grant, whereby it is for as a limited purpose or for a specific purpose. Let's say that there is one of the beneficiaries who is maybe in school and they need to get the school fees paid. So you can file for that special grant. Maybe there's also one who is sick, you can also file for a special grant. So basically in my, I believe that if there is any dispute, and then you find that there are those types of grants, and let's say that this person estate maybe he had a certain parcel of land somewhere, and maybe let's say that there are some crops that were planted in that parcel of land. There is that grant that they can actually apply for, which is for purposes of collecting and preserving. Okay, then there are those. There is also that other type of grant where the court will want to get someone who is going to manage the estate before the dispute has been resolved. So basically, maybe to hit the nail on the head, is that a special grant in this case will be the best way to go about it. I think that is all. I don't know whether I'm audible.
Hello, I don't know. Lavins is. I don't know where he's gone. Lavins, are you in the meeting?
Hey, sorry. I think someone logged me out, but it's okay. So I was saying, you haven't given me the documents and the forms, and assume that estate has to be dispensed with in total. So there's no perhaps special limited grants and water view. Yes, so just give me the forms. I mean the documents that will support. But then you haven't even given me the petition. What type of petition will be filed and the documents to support this petition. That's what I need.
All right. I think yeah. I may have gotten your answer then, or your question. Sorry. So basically, yeah. This is you can file the petition maybe on Form 80. There's also the affidavit in support of the administrator. There's a PNA 57. There's also PNA 12, there's PNA 5, and then we also have Form 38, which is a consent by the beneficiaries. So basically those forms we relate to the sureties. We also relate to the affidavits of justification of the proposed by the proposed sureties, and also the last form that I mentioned, which is the consent form under Form 38. Okay.
Thank you.
So
no further questions. Thank you. Thank you. So Lonka, I'm okay. I'm fine. So
now for me, but no, I was also no. Are you in?
Yes, I'm in.
Yeah. Okay, you could
So,
proceed. You too, because yeah.
Yes. Mr. Philip, good evening.
Good evening, sir.
So I have a few questions. So my first question is, what are the essentials of a civil suit? What must you consider before instituting a suit?
Okay, thank you very much. So the first thing that you have to consider is a course of action, whether there is any course of action. The number two is the jurisdiction, the pecuniary jurisdiction, and you can also consider the territorial jurisdiction. Then number three, you also have to consider the locus standi, the right of a party to bring a suit. Then number four, you can also consider the statute of limitation. Whether the case is started bad, then you can know how to proceed from there. Among other things that you have to consider, just to mention but a few.
Yes, then you are very right. Number two, this is the second last question. Differentiate between a charge and a mortgage.
Okay, thank you. Thank you very much for that. So basically, in simpler terms, a charge, now that you have said it, I think it becomes extremely difficult to be able to distinguish or to explain the charge. But basically, a charge, I don't want to call it an inhibition, but basically this is where you have a property. Maybe to use an illustration, you have a property, and then this property you want maybe to secure a facility, and this one mostly happens maybe individually or maybe companies where you want to get some facilitation in terms of monetary facilitation by an institution, mostly a bank, and where you deposit that specific instrument or certificate of title or whichever document that may be, whereby the same is held until you are able to repay that specific loan. Where a mortgage is where you purchase maybe a certain property with the help of maybe an institution, where you're now required to be making some, some payments. They could be monthly, or as the case may be, as per the agreement, the agreement between you and the financial institution.
Okay, and the last question. Suppose I'm your client and we entered into a retainer agreement. Then I fail to pay you. So give me two instances where you will enforce, two ways how you will enforce the fee arrangements between me and you. I failed to pay you. Give me two modes.
Okay. The first way is that you can maybe prepare a bill of costs, file it in court. It is, mostly is hard by, I think the EO or the registrar, the deputy registrar, and orders are given accordingly. So once the orders have been given, then the normal process of, execution of that order will occur, whereby maybe you can get one of the property, or property is a movable property, which is actually the easiest way the easiest mode of execution. You can get maybe a movable property of your client, and then maybe you can sell it and reclaim your legal fee. For now, I would want to believe that that is the only answer that I am getting from the top of my head, but I would love if you can also clarify that for me. Thank you.
Yes. Okay, so I'll give my comments, then Lavins will close. Now I'll start with that question. Enforcing fee agreements. So there are two ways, Mr. Phil. So normally, each party bears its advocate's fees, regardless of whether you win or lose the case. So I am obliged to pay you since we have agreed because there's a retainer agreement. It's a contract, so it's binding. So I'll have to pay you. Also, you need to understand that there are certain reasons as to why I may fail to pay you. So when this happens, then you as the advocate will have two options available to you. One, you'll have to enforce the agreement through alien. I'm sure maybe you have not reached that topic under professional ethics. So you will enforce that agreement through alien. Number two, you can enforce by suing me, your client, for the recovery of fees. So what happens, the second option, where you will sue me, what happens is that you will have to send me, as a matter of law, you'll have to send me the fee note. A fee note is like a demand, it's the quote unquote the demand letter. So you send me the fee note. Now, if I fail or if I contest that fee note that you have sent to me, then you as the advocate will have to file what we call an advocate-client bill of cost in the High Court, which must set out all the services that you have rendered to me. So that particular advocate-client bill will then be taxed by the taxing master, and a certificate to the effect shall be final unless it has been set aside or altered. So if the client refuses to pay even after that taxation, then the third option will be you will file a normal suit for recovery of the fees. So when it comes to lien, which is the second option that I earlier highlighted, and I'll refer you to the case of Barrett. Barrett is B-A-R-R-A-T versus Cloud Thomas. What happened? Sorry, the case basically said an advocate lien is an extraordinary right granted to lawyers to retain a client's property deposited with him, including crucial and original documents, until his or her bill for services and the expenses has been paid. And Mr. Philip, it's very dangerous to sell a client's property. What you do, for instance, if you deposited maybe a title deed, you cannot sell it. What you do, you hold it, especially if it's original, you just keep it in your drawer and you demand payment. So until that payment is effected, that's when you will release that document. Lien is a long topic, but that's the overview of what a lien is. It's just a right of a lawyer to hold a client's property or money until payment has been made for his services. So the two options are you either sue, you do an advocate-client bill of course, or you do a lien. Then the issue of charges and mortgages. Now, the first question you answered correctly, I have no issue with it. So a charge is basically a security for a loan with an undertaking or a promise for repayment. So once you do that, then it confers certain rights to the lender from the charger. The chargee from the charger, sorry. So what you need to know, when you read Section 80 of the Land Act, it operates only as a security. It does not transfer or convey any interest or the rights in land. Whereas in mortgages, it is basically a conveyance or an assignment of a land with provision for reconveyance upon discharge of obligation. So what happens is, if I put it in simpler terms, in a mortgage, basically you are telling the lender, take my land and hold it until I pay you back. So the lender will take the land, transfer it in its own name, and then hold it until I pay them their money. Whereas in charge, it's give me the money, and if I fail to pay you, then you may take my land. So it will only operate as a security, but there's no transfer of interest. So that's the difference. A charge only confers rights on the chargee to enable him recover the money plus interest. Whereas in mortgages, you transfer the interest and you tell the lender to hold it until he pays you back, until the person who borrowed pays you back. So that's the difference. Mr. Solonka, that's all for me.
Thanks a lot. Thanks a lot. Yeah, I mean, it's gotten to 11.
Okay. Solonka.
Yes, Lavins.
Awesome. Cops, just to give me feedback quickly. So
okay, no problem.
Okay, thanks. Gasheru, when I asked you about the legal profession, not being a business entity but a profession dedicated to the public service, I wanted, I laid a trap. Okay, it was a bait, and perhaps you consumed that particular bait, and you found yourself trapped. The keyword there is business. Okay, so when I think you're keen when the case of George Okeo Omwansa was being mentioned, the case that sort of changed or adjusted the tides on marketing when it comes to advocates. So I wanted you to give me, what are the effects of advertising? For example, advertising will demean the profession. So the ban on adverts, preserves that dignity of the profession. And the other thing that I also wanted you to talk about was, legalizing advertising of law firms would sort of polarize, the law firms by creating firms for the rich and for the poor. And then the last but not least, the rich and larger law firms will perhaps push the low income, companies or, law firms out of business, since the established ones would afford quality advertisement, which will be out of reach for the low income firms. So those are the kind of things that I wanted you to capture. So whenever you ask a question, know exactly what are the keywords in this question, what is the trap for me, where is the bait? Okay, so at the end of the day, the panel would want to know, how, what are your analytical skills like? What are your, critical thinking skills like? So yeah, so for now, I think just tend to, focus on those three things, the bait, the trap, and the keywords. And then the other question that I asked was about, what is it? The type of grants. Yeah, that one you did perfectly well. And perhaps for the consumption or for your assignments, the rest of the class, try and know what, what is the petition? The petition could be P&A 80, that's okay, but it depends when it comes to subsequent documents to be attached. For example, for petition of letters of administration intestate, the instances where you have a widow or a widower, and the adult children as survivors. And then you also have widow or a widower with minor children as survivors. You see those documents that you're going to attach, in as much as it could be from P&A 80 for the petition, that's okay. But the subsequent petitions will differ in one way or another. For example, the grant of letters of administration intestate, when it comes to a widow or a widower with minor children as survivors, you'd see that P&A 57, which is the guarantee of personal sureties, will be included here, and it may be omitted in a widow or widower where the adult children are survivors. Okay, so those are the kind of things that I want to perhaps delve into at your own free time and at your own convenience, to just try and distinguish how are the two distinct of each other. because again, the trap and the bait will be there, but you wouldn't know how to distinguish, the two. Okay, so the other question was about what? Remind me, please.
Departem.
Yeah, thank you. The doctrine of audi alteram patem. In simple words, and I told you, like these panelists will even ask questions in Latin. And I sent a list of Latin words that are likely to be asked, in any oral, setup or even in the exams. So the principle of audi alteram patem, you put it well. I mean, it all boils down to
Solonka, are you here?
Yes, I'm here. I really don't know what's happening.
Okay.
Exactly. I mean, someone keeps logging me out. I don't know, but I think the problem is persistent and it's annoying, but it's okay. We'll move. So I was talking about the principle of audi alteram patem. It boils down to the right of the adverse party to respond to any evidence adduced against them. Okay, so you mentioned Article 47, I'll mention Article 48, the access to justice. At the end of the day, justice should not only be done, but should also be seen to be done. So if you deny the adverse party, the right to respond, then you are sort of, impeding access to justice, or you are just trying to, suffocate this particular, child when it comes to justice. So at the end of the day, what will be delivered wouldn't be, a fully born, child of 9 months. That will be stillborn, when it comes to justice. You don't sort of, impede access to justice, based on the denial of the adverse party to respond, to the evidence, adduced against them. So the principle of the doctrine of, audi alteram patem would likely, surface in that particular instance. And also, it always goes hand in hand, with the principle of nemo judex causa sua, which loosely translates to you can't be a judge in your own case. So at times, you'd find that conflicted situations, for a judicial officer. So to allow this adverse party, could be an accused person, he or she may not feel like justice, will be served. When you're there, you have interest in that particular case. So you will sort of perhaps deny him, that particular right to respond perhaps to the, evidence adduced against them. It happens, I mean, in our daily occurrences, in the courts and, all those places. Yeah, so that's basically it. So you did well, and I will encourage you to maintain that confidence, so you can even build it more, because it's satisfying, to know you know where to balance your, or how to balance your confidence, and I love that. So perhaps if you just add, more energy to it, and even extra knowledge, because you're well off. I mean, right now you're okay. I love how you grasp the questions, how you try to filter, and how you try to perhaps distinguish, what should come first as my strongest point, and the rest of you should know that in areas whereby you're asked to perhaps give 2 answers, 3, your first answer should be your strongest answer. Even in an exam in CLE, your first answer should always be the strongest, okay? So when the examiner reads the rest, at least he or she had an idea of what you're trying to communicate based on your first answer. And if your first answer is weak, then the human beings, they'll assume, you perhaps you don't know exactly what you're talking about. Yeah, so long with that, I beg to rest my case. Thank you.
Oh, that's fine. That's fine. It's 11, but I saw Nyabio was raising her hand for long. What, Nyabio, did you have a question maybe? And who else? There's somebody else whose hand was up, so that we can wrap it up. And all those who didn't get a chance to participate today, you'll have more time to do it next week during the weekend.
Good night, Brian, Noah, and Lavins. Mine was I wanted to attempt the orals, but then I got cold feet, and I think God saw that I've gotten cold feet because it's already past time. So maybe I'll try next time.
Okay, no, don't get cold feet. It happens to all of us. Everyone gets cold feet. I also get cold feet. Lavins gets cold feet. No, everybody gets cold feet. Don't have cold feet. It's going to work out in the end. Next time, maybe we could start with you, and my questions will be fair. Okay. Actually, I'll give you the laxity of go prepare, and then when we meet, you'll tell me where you want me to ask you questions from. That's what we'll do next time. It actually happens in our.
Okay.
Okay, Usana. Harriet, please go on. Do you have a question?
Hi, I actually didn't have a question. I wanted to chip in on the issue of the registrar cancelling title. And
please go on in brief too.
Okay, there's a decision that was released this year, Judicial Review 23 of 2019, and the court was of the opinion that the registrar lacks capacity to cancel the title, and that the responsibility lies with the court based on Section 80, subsection 1 of the Land Registration Act, and that the wording in Section 79 is actually rectification and not cancellation of title. So as per now, the registrar does not have the mandate to cancel title.
Thank you so much for that. Thank you. I appreciate it. So the issue is rectification of title and not cancellation of title. Thank you for that. I appreciate that. Thank you for that clarification. Is there anyone else? Unless my colleagues Lavins and Noah or anybody else has anything to add, we could close it up. I appreciate you coming, and I appreciate Lavins for coming. I also appreciate Noah for coming. Alex apologized, but he'll be joining us next week. So yes?
Ronga, maybe kindly I could request Agoro to share that judgment. Maybe anaweza share kwa group, maybe.
That's fine. Agoro. She'll do so. Now, yeah, unless anybody has anything to add, we could close it up. Next week we'll meet. Kindly prepare. Thank you very much.
Thank you.
Thank you.
Thank you. Good night.